Third-party issues. A third party that benefits from a contract entered into between other parties is still a third-party beneficiary. Intended third-party beneficiaries, parties to the contract who intend for third-party beneficiaries to benefit from the contract. The TPB has the right under the contract. Incidental third-party beneficiaries stand to benefit from the contract, although not intended by parties to the contract, and has no rights under the contract. Determining third-party beneficiary status. Whether a third-party beneficiary is an intended beneficiary under the contract is a question of fact. Courts look at the following factors. A, is third-party beneficiary expressly designed or designated in the contract? B, does third-party beneficiary directly benefit from some performance under the contract? C, does third-party beneficiary have rights under the contract? And D, does third-party beneficiary stand in such a relationship to the promise under the contract that an intent to benefit the third party can be inferred? If answer to any of the above is yes, more likely that third-party beneficiary is intended. Third-party beneficiary characteristics. Not party to the contract. Third-party beneficiaries are merely beneficiaries. Intended third-party beneficiaries have the right to sue for breach of the contract even though they are not parties to the contract. Creditors to third-party beneficiaries, benefit is conferred based on a debt owed by the promisee to the contract. Donee third-party beneficiary, benefit is conferred gratuitously. In order to enforce rights under a contract, a third-party beneficiary right must vest. Vesting of rights occurs when the third-party beneficiary either A, accepts the benefit of the contract in a manner requested by the parties in the contract, B, sues to enforce, which brings the suit to enforce the contract, or C, detrimental reliance, detrimentally relies on the contract, material changes, position and justifiable reliance on the contract. Enforcing the contract. Third-party beneficiary can sue promisor. Promisor can assert any of his own defenses. Promisee can sue promisor at law and equity for specific performance. Creditor beneficiary can sue promisee on existing obligation between them. Donee beneficiary may only sue promisee if detrimental reliance exists. Assignment. An assignment is a transfer of rights under a contract to a third party after the contract is formed. A party, Assignor, can assign rights under a contract to a third party, Assignee, who is now in a contract with remaining party, the obligator. Consideration, not required, but assignment without consideration is considered gratuitous. Assignor can only transfer the rights they have in a contract at the time of assignment. Common law limitations. Common law bars any assignment that substantially changes the duties of the obligator. Assignment of payment is not a substantial change. Assignment of rights fails if the obligator risk is substantially altered. Contract limitations on assignment. Contract may contain non-assignment clauses. Non-assignment of contract bars delegation of assignor's duties only, does not prohibit assignment of rights. Non-assignment of rights bars the right to assign, but not the power to assign. Upon assignment, obligator may sue assignor for breach. Assignment as void. Assignment will be ineffective. or assigner has neither power nor right to assign. Revocability and enforcement of assignments. Revocability, gratuitous assignments may be revocable. However, assignments made for consideration are irrevocable. Assignments for consideration, irrevocable. Gratuitous assignments, revocable. Exception is that a gratuitous assignment is revocable if either A, obligor has already performed, B, assignee has received a written claim or a tangible object signifying a right to collect, like a stock certificate, or C, detrimental reliance by assignee, such as an estoppel. Assignee right to sue. Assignee can sue, 1, the obligator for non-performance, and obligator can raise any defense to the contract that he could have raised against the assignor. Assignor for the breach of any of the following assignor's implied warranties, no prior assignment of the same right, the right to assign was not subject to defenses, no interference with a assigned right. Delegation. A delegation occurs when one party to a contract, the delegator, delegates the duties she owes to another party to the contract, the obligee, to a third party, the delegee. Obligee must generally accept performance from delegee. Only duties may be delegated, whereas rights may be transferred to a third party via assignment. Liability. Delegator remains liable for delegee's performance. Obligee may sue delegator for non-performance by delegee. Obligee may only sue delegee if the delegee has assumed duties of the entire contract. Exceptions. Duties are non-delegatable if A, duties involve personal judgment and skill, B, delegation materially changes the obligee's expectancy under the contract, C, the contract prohibits delegation, or D, prohibited by statute or public policy. Delegation versus novation. Novation arises when both parties agree that a substitute person will take over duties under the contract, whereas a delegation occurs when one party independently decides to delegate duties to a third party.